reason why we're seeing an increase in these PAGA cases too, and it's due to the case law. And I'll get into that here the next few slides on how the case law developed, and the plaintiff's bar has really just moved to the PAGA cases because class action waivers on the federal front and federal case law has really put teeth into arbitration agreements that contain class action waivers. So I'll jump into that right now. And again, bear with me, I've got to go through the Federal Arbitration Act. It's a key piece of the elements here that we're talking about today. And it's the issue that's really driving the issue in the Viking case. So the Federal Arbitration Act's been passed by Congress a long time ago. It's been in place for a long time. And it was enacted by Congress to, in a response to judicial hostility against arbitration agreements. So the federal Congress said, look, we want to have arbitration agreements enforced, and we don't want to have this hostility towards them. So they passed the Federal Arbitration Act. Requires the courts to rigorously enforce arbitration agreements according to their terms so as to facilitate streamlined proceedings. That's the whole goal with arbitration, and that's a key element here that's being discussed in all these cases, that the arbitration is a lot quicker, faster for the parties to get a resolution. Now, so the FAA creates this federal framework to ensure that these private agreements to arbitrate are enforced according to their terms. And the key aspect here, because it's federal law, the FAA preempts state laws that interferes with its purpose. So it's a quick overview of the FAA and how it's going to play out here in these cases. Now, in 2011, we've got a big case coming out of the U.S. Supreme Court. It's the AT&T Mobility versus Conception case. And here, the U.S. Supreme Court held that in the consumer context, so when you're still signing up for a cell phone, cable service, something like that, and the company has an agreement with the consumer, there could be a class action waiver in that agreement. And the U.S. Supreme Court upheld these arbitration agreements with class action waivers in them in the consumer context. So that was a big development in 2011. Employers were starting to rely on that case to argue that it applied to the employment context as well. In 2014, the California Supreme Court issued this ruling in Iskanian versus CLS Transportation Los Angeles. Now, the California Supreme Court basically said that in the employment context, we understand the FAA requires these arbitration agreements to have teeth, and it recognizes the class action waiver is enforceable. So that's going to preempt California state law on this class action waiver issue. So the class action waivers are enforceable. But Iskanian, the California Supreme Court said PAGA, however, is different than a class action. And because of the differences, and I won't get into all the details they went through, they said basically PAGA is not part of this FAA preemption. It falls outside of the FAA's coverage. So therefore, California employees could still maintain these PAGA claims. And to the extent an employer has an arbitration agreement that says the employee can't bring a PAGA claim on a representative action in arbitration, that's unenforceable under state law. And we lie outside of the FAA's coverage. So whatever the U.S. Supreme Court said in AT&T Conception doesn't apply to PAGA. Now, in 2018, the U.S. Supreme Court came back again in the Epic Systems case and held that in this time, held that in an employment setting, an employment arbitration agreement required employees to bring only individual claims and arbitrations are enforceable. And Epic confirmed Conception's holding that the agreements that had the employees forego class or collective actions were enforceable under the FAA. Now that brings us to, I wanted to do a little graph here too, to kind of set out the Iskanian holding and how this issue is being set up for the Viking case. So under Iskanian, we have the employer here doing business in California. They hire an employee. the employer implements an arbitration agreement with a class action and a PAGA waiver. And so if the employee files a lawsuit against the employer, this class action PAGA waiver is in place. And at least the employers were arguing that. Now, the California Supreme Court in Iskanian said, well, it's not really like this. We've really got another party involved here. It's the state of California that really, as Anne mentioned, deputizes the private employee to bring a lawsuit. So it's not really the employee bringing the lawsuit, but instead it's the employee stepping into the shoes of California to bring this PAGA lawsuit against the employer. So it gets around this PAGA waiver. Now, Iskanian recognized, though, that the class action waiver was still enforceable, but PAGA is, because it's state law, would fall outside of the FAA coverage, the preemption under federal law. So again, it's very simplified. I kind of hesitated to even put this graph together, but I think it brings some of the key issues somewhat into light. So the key issue now in Viking that the U.S. Supreme Court is reviewing, and hopefully we'll have a decision by this summer, is whether the employee is more like the state in bringing these PAGA claims, or is the employee more similar to themselves bringing, that's subject to this arbitration agreement and is bound by this arbitration agreement, where they can only bring individual claims and not these collective class actions or representative actions under PAGA.